several additional issues have been raised. The bench found it necessary to address these issues so as to ensure both the completeness of the record and finality in the issues raised. During the submissions, an issue was raised concerning the directions issued by the three-judge bench and the transmission of the files in Nairobi Petition E565 of 2024, Kerugoya Petitions E013 and E014 consolidated, as well as E015 of 2024. A review of the CTS, that is a case tracking system, confirms that the petition in E565 of 2024 was filed on the 18th of October 2024 at 8 o'clock a.m. Later that same day, approximately 5 hours on, at 1:51 p.m., Justice Chacha Mwita dealt with an application filed under certificate of urgency which had been submitted alongside the petition. By 5:33 p.m., roughly 3 hours after the earlier application, a notice of motion application dated the 1st of October 2024, it was dated the 1st of October 2024, was filed, this time by the respondents seeking the following orders. 1, that the application be certified as urgent and service of the application be dispensed with in the first instance. 2, that pending the hearing and determination of that application, inter partes, this Honorable Court be pleased to set aside, vary or review the orders issued on the 18th day of October 2024, that is the interim conservatory orders. 3, that in the alternative, this court be pleased to set aside, vary or discharge the ex parte orders issued on the 18th day of October 2024, and 4, that this Honorable Court do issue any other orders it deems fit in the interest of justice. Following its empanelment on the 18th of October 2024, and having received directions from the Office of the Deputy CJ, the bench deliberated on the appropriate directions to be issued. On the 19th of October 2024, at 12:20 p.m., the bench issued the following directions. That in light of the urgency of the matter and the weighty issues raised therein, we direct that the application be served and responded to forthwith for hearing inter partes on Tuesday, the 22nd of October 2024 at 11 a.m. in open court number 18. Petition E013, on the other hand, was filed on the 25th of September 2024 at 8:33 p.m., while petition E014 was filed on the 2nd of October 2024 at 7:07 p.m., both way past official working hours of the court. The CTS will further show that an application in E014 was filed on the 30th of September 2024, and directions were issued on the very same day, although the matter was not certified as urgent. Subsequent directions and a ruling issued on the 11th of October 2024 resulted in the consolidation of petitions E013 and E014, followed by an order for empanelment. As the record on CTS will further show, the directions issued by the court in E014 of 2024, which were issued on the 2nd of October 2024, were again issued at 6:22 p.m., which is outside of what one would call the routine working hours of the court. This was due to the urgency demonstrated in the application, which sought directions regarding the then ongoing public participation process. The bench takes great exception to the petitioner applicant's conduct that, when favorable to them, issues of orders, rather orders issued outside of what one would refer to as the normal working hours of the court raise no concern. However, when the court acts in an instance where it has been moved by any other party and likewise proceeds to deal with an application at hand, the applicants show their indignation. Moving to petition E015, the CTS again would show that the same was filed on the 18th of October 2024, and once again following the directions issued by the court, this bench was empaneled on the 18th of October 2024 to hear all the three petitions, that is E565 of 2024, E013, E014, and E015, all of 2024. From this sequence of events, it is notable that the interaction between counsel and the courts on an almost real-time basis is not novel, and is in fact a practice that counsels are well familiar with. The CTS enables both counsel and the court to operate in real time, transcending traditional time limitations. This fact also buttresses the argument that with the advent of the CTS system, it is not unusual for courts to issue directions within the filing of an application or outside of what once again would be referred to outside the routine work hours of the court where circumstances do so require. Moreover, in raising the issue of improper seating, the applicants omitted a crucial fact, which was that the court had been moved by the respondents in petitions E565 of 2024 and E015 of 2024. As such, the court did not convene suo motu, but rather in response to the applications before it. The applicants have repeatedly referred to this convening as a sitting of the court, a term that we feel as a bench requires clarification and demystification. It is a matter of judicial notice that since the onset of the COVID-19 pandemic and the introduction of the case tracking system, the tradition of dealing with certificates of urgency has since evolved. Allow me to quote the practice direction number 19A of the High Court Practice Directions of the 11th of January 2022, which states as follows, that applications filed under certificate of urgency shall be considered by the judge, we emphasize here, at the earliest opportunity. While the practice directions also stipulated that applications filed after 12 p.m. may be considered the next working day, the full adoption of the e-filing system across the judiciary has largely rendered this provision obsolete. Applications are now processed almost in real time, a fact well known to the justice users across the country and which we have demonstrated in this ruling. Furthermore, Practice Direction 19B confers discretion upon the court to issue orders or directions without the attendance of advocates or parties. This implies that the court can indeed issue directions on an application without the need for a formal seating. The relevant provision once again reads as follows: that the court may, in its discretion, issue orders stroke directions without the attendance of the advocates or parties. I end quote. In this case, the issue has been raised that this court allegedly served and considered an application by the respondent on a Saturday outside of the official court hours. The ordinary definition of a sitting, as provided in the Black's Law Dictionary, is a formal occasion when the court convenes to conduct its business. In this instance, no such formal sitting occurred. In this instance, where I repeat, no such formal sitting occurred, rather, the bench merely conferred and issued directions electronically as expressly permitted under Practice Directions 19B. This is markedly different from a court session in which the bench is convened to hear and determine a matter. Furthermore, no evidence or proceedings have been presented before this bench to support the claim that a formal sitting did take place. Accordingly, it is only fair and reasonable for the parties to dispel any notion that this bench convened to hear arguments from any party ex parte before issuing directions. No such formal sitting took place, the court again emphasizes, and directions were issued electronically in line with established practice and procedural rules. We do, however, recommend that the current practice directions and relevant statutes, such as the High Court Organization and Administration Act, be amended so as to provide a much needed further clarity on this subject. Moreover, for the avoidance of doubts, and out of all the prayers sought by the respondent, only prayer number 1, which sought to have the matter certified as urgent, was granted. No other reliefs were considered or granted at the time. It is evident that the court was fully cognizant of both the urgency of the matter and the potential repercussions that granting any further ex parte orders could have had on the prevailing status quo. With this understanding, and in an effort to balance the scales of justice, the bench issued the directions that are now being challenged. We hold the view that there was nothing unconventional in the manner in which this bench dealt with the 2 applications filed under certificate of urgency. As regards the arguments that directions had already been issued by the respective courts for a mention before the bench on the 24th of October 2024, the arguments by the applicants appear to insinuate that the bench ought to have retained the date. For clarity purposes, this date had not been given by this bench, rather this date had been given prior to the empanelment of this bench. However, upon empanelment of the bench, the applications under certificate of urgency, the ones that I have just referred to, were filed, which applications were dealt with, and we feel rightly so. Being seized of the matter, it is our view that the bench retains the discretion to issue appropriate directions depending on the developments and in light of its mandate as it did, having been moved by a party under certificate of urgency. With respect to the claim that was raised on discriminatory transmission of files to the bench, it must be emphasized that this bench has no role and no control whatsoever in the administrative processes that occur prior to its empanelment. Concerns have been raised about delays in the transmission of certain files, but it is crucial for us to clarify that the term transmission in this case may not necessarily refer to the physical transfer of documents. In the context of judicial processes, particularly with the advent of digital systems, transmission may very well refer to the electronic movement or assignment of case files within the judiciary's digital infrastructure. We say this on the strength of the fact that with the CTS, all filed documents are available in real time across the judiciary, eliminating the need for physical file movement. Let me refer once again to practice direction number 41A Roman 2, which provides that advocates and litigants shall have access to court information electronically. While this court cannot and will not speculate on the causes of any delays in file transmission, the bench nonetheless finds no basis for concluding that such delays amount to any form of procedural omission on the part of the bench, as no such evidence has been presented. The applicants have equally in their submissions attempted to cast aspersions on the proceedings of this court, some of which I have already referenced. That is that the court was convened on a Saturday, stating that there is no urgency in this matter, and so there was no need to convene the sittings of the 22nd day of October 2024, that this matter is being given priority over other petitions which have been filed, an insinuation that the bench is part of a conspiracy to infringe the petitioner's Article 50 right to fair hearing, and what I have again alluded to, that the transmission of the files from the Kiruhoya High Court took place with what has been referred to as a supersonic speed. One of the counsels went further by intimating that an exercise akin to the radical surgery may well be forthcoming, a statement which the bench, with tremendous respect, perceives as a veiled attempt at intimidation. The bench feels that such remarks are regrettable and wholly inappropriate. This bench remains firm in its duty and will not be swayed or influenced by any form of intimidation, regardless of its source. The bench takes the view that the applicants appear to selectively focus on aspects that favor their position while conveniently disregarding that the clients, that the applicants are presently benefiting from final conservatory orders, which this bench did not deem it fit to lift. Despite having obtained final conservatory orders, as the court has already observed, it is now apparent that the applicants no longer perceive the urgency in this matter. Instead, they seek to cast aspersions on this court for addressing the matter with the necessary expedition. Such conduct is contradictory and undermines the very urgency that the applicants had initially invoked. The bench notes that the issues raised in this petitions have on various occasions and before different judges consistently been certified as urgent and as involving substantive constitutional questions. This underscores the gravity and significance of the matters at hand. One of the counsels again insinuated that this bench is part of a conspiracy to violate the petitioner's right to a fair hearing under Article 50 of the Constitution. The bench finds that these submissions are without any foundation and wholly without merit. This court has not issued any rulings or directions that would suggest such an intent. It was made for the sake of the gallery, and we find it unnecessary to therefore address it further, save to reaffirm that this court remains fully committed to upholding the Constitution and the rule of law, and holds that the accusations made by the applicants against this bench are entirely without merit. On this link, the last part of the link is whether the matter raises issues of public interest which require expeditious disposition of the petitions. The applicants have urged that the applications before the court are not urgent and have loudly wondered why it was necessary to give directions for hearing of the applications on the 22nd day of October 2024. In response, the bench quotes Article 131, which establishes the office of the President and the office of the Deputy President, and also we have cited Article 147 with regards to the functions of the Deputy President, just to lay context. And the context is this, according to the bench, that the first petitioner has been impeached under Article 145 of the Constitution, marking the first instance of such an event in Kenya's history. The impeachment of the said petitioner has undoubtedly garnered significant public interest, and these court proceedings represent a direct challenge to that impeachment. It goes without saying that these legal proceedings are of paramount concern to the citizens of this country. To suggest, as the applicants have, that this matter lacks urgency and does not warrant prompt adjudication is disingenuous and dismissive of its far-reaching implications. We have taken the liberty to define the term public interest in the Black's Law Dictionary, and you will also find the Supreme Court of Kenya's definition of public interest in the case of Stewart versus Roscoe, which permit me not to get into. Safe to say that from the foregoing, a matter is of public interest if the holding on law affects a considerable number of people in society, if the holding in law involves government and or government agencies, if a determination of law affects the proper functioning of public institutions of governance or of the court's scope for dispensing redress, and if the holding of law affects the mode of discharge of duty by public officers. These proceedings, in our view, as the bench, raise enormous public interest, and it is in the interest of the public that these proceedings are heard and finalized most expeditiously. Therefore, the aspersions cast by the applicants concerning the directions for the hearing of the applications before the court on the 22nd day of October 2024, in our view, lack basis, and they are dismissed. Thank you.
This position, having carefully